may I ask the first question to you? This, as I have said, in the context of Indian Arbitration Act and the decision of, I am referring to the decision of SBI General Insurance versus fish spinning, you know it very well, where the courts have discouraged from intervening in complex factual disputes at the referral stage. How do you view the balance between the tribunal's autonomy under Section 16 and the limited role of the courts at the referral stage under Section 8 and 11, which I have paraphrased? So how you can say that this balance can be struck, and if whether there is any risk of the parties exploiting this to delay the proceedings?
So, respected Justice Sikri, esteemed panelists, ladies and gentlemen, namaste and a very good evening to all of you. It is my proud privilege to be speaking and to be a part of this esteemed panel and to be speaking in front of such accomplished professionals. Now, the provisions, which are sections 8, 11, 16, and their scope and interplay has been the subject matter of various judicial precedents. Section 11 in particular, which deals with appointment of arbitrators, has seen an evolution of sorts. And over the years, both the legislature, by introducing various amendments to this provision, and the courts, by their judgments, have given due importance to tribunals' autonomy. That said, the balance between tribunals' autonomy under Section 16 on the one hand and the limited role of courts at the referral stage under Sections 8 and 11 is fragile, as I see it. And this fragile balance is apparent from the various judgments on the scope and ambit of Section 11 and the never-ending saga of judicial interpretations. From Konkan Railway, where the exercise of power under Section 11 was held to be an administrative function, to SPP and Patil Engineering, where it was held to be a judicial function, and then later in National Insurance versus Bokhara Polyfab, where the scope was further enhanced to the amendments which were brought about in 2015 by inserting Section 11.6a, and then the judgments on the scope of that 11.6a, Mayavati Trading and Durofel. Section 11, I would say, has come a full circle. But despite all the conundrums, Section 11 has been the life support to the field of arbitration in India. To maintain this balance, when we look at the Arbitration and Conciliation Act, the provisions try and maintain that equilibrium and balance. Section 16 gives the arbitral tribunal the power to rule on its own jurisdiction, including any aspect concerning the invalidity or existence of the arbitration agreement. Section 5 mandates that no judicial authority shall intervene except and unless as provided under the statute. Section 8 is another example which mandates that a judicial authority before which an action is brought in a matter which is governed by an arbitration agreement, the judicial authority is required to refer that dispute to arbitration, and the scope of the arbitral tribunal, scope of the judicial authority in such a situation is to see the existence of a prima facie existence of an arbitration agreement. Section 11.6a is yet another example where the scope is only to see existence of an arbitration agreement. Courts on their part have also played a proactive role in trying to ensure that the balance is maintained, the equilibrium is maintained. The judgment which Justice Sikri referred to, SBI General Insurance versus Chris Pinnick, throws light on how courts have tried to maintain that balance. And what it lays down is certain principles which are very informative. It provides that at the stage of deciding a Section 11 application, the courts should not conduct an intricate evidentiary inquiry as to whether the claims are time barred And this is something which should be left to be determined by the arbitral tribunal. That said, in the same judgment, relying on Vidya Drolia, which is another landmark judgment, the court held that in exceptional cases and circumstances, however, if the claim is ex facie time barred or it is deadwood, is the expression they use, the court can exercise jurisdiction not to refer the parties to arbitration. The court further held that tests such as eye of the needle test or an ex facie meritless claim, etc., though provide and ensure that court's interference is restrained, however, applying these tests itself requires some sort of an examination of evidence, etc. And these tests, the court held in SBI Insurance, that are not in conformity with the principles of modern arbitration, which places tribunal autonomy and judicial non-interference at a very high pedestal. So broadly, the position which emerges from SBI Insurance is that a court will only look at the existence of the arbitration agreement and will only refuse interference in cases where, let's say, a claim is non-arbitrable at all or is ex facie meritless. In this particular case, the issue involved was whether a situation of accord and satisfaction should be referred to tribunal or it should be decided by a court, and the court said this is a mixed question of facts and law and should be within the exclusive domain of the tribunal. Another judgment which Justice Sikri mentioned in his opening address, the interplay between arbitration agreements under the Arbitration and Conciliation Act and the Indian Stamp Act. That judgment also provides that at the referral stage, a court should not conduct a laborious test or a contested inquiry. So these are broadly some of the issues which have emerged from the judgment and which assist us in, trying to see if a balance can be maintained. The second aspect of your question, sir, was that is there a risk whether the parties can exploit a situation? And the answer to that, according to me, is yes. And this can happen both at the pre-referral stage and also before the tribunal. In my view, at the pre-referral stage, despite all the judgments and the tests which are laid down therein, there still exists certain elasticity, and a litigant can take use of that by taking pleas to defeat the arbitration. Conversely, if there is an ex facie time-barred claim and the court wants to adopt a hands-off approach, a litigant may nonetheless be sent to arbitration when that should not be the case. Before the tribunal, a party can again misuse the provisions and can file a bogus Section 16 application, which is also done in some cases to drag the feet and delay the proceedings, but that is still, according to me, not a big concern because of the timelines which are prescribed in the statute, where the arbitration has to be concluded in a certain time frame. So to conclude, sir, I would say that I am cautiously optimistic because of all the recent developments, and these recent developments are steps in the right direction and help in maintaining an equilibrium between judicial non-interference and tribunal autonomy.
Which you have said, and only when these conditions are satisfied, court should decide first of its own rather than relegating it to the tribunal. I think what I feel, please.
So just to give the Indian context, because we heard the English context and we heard what the corporates feel and the most important stakeholders being clients, what they feel. So the positive and negative effects of competence are recognized, as you rightly said, in chloro control. They are also recognized in SBI General Insurance and the 7th interplay, the stamping judgment. And in all these judgments, the Supreme Court has said that the positive effect is that it enables the arbitrators to rule on their own jurisdiction, and the negative effect is that it deprives the courts from exercising their jurisdiction. However, what they also say is that the arbitrators are to be the first judge and not the sole judge, and that's important. And in this background, if one were to see the role of courts when they are faced with allegations of illegality or fraud In my view, the approach has to be balanced and cautious. And why I say balanced and cautious? Because not in every situation you can follow the same principle, and this has been a vexed issue in itself and has seen its own share of various divergent judgments. But I just want to give some hope to the stakeholders here, because what we saw and what position we have now, that should give you some comfort. So when I say this has seen its own share of divergent views, so it started with N. Radhakrishnan and Maestro Engineers, where the Supreme Court said that the issue of fraud is not arbitrable at all. Then came the judgment in Ayasami, where Supreme Court introduced the seriousness of fraud test. And here the court held that if the allegation of fraud is of such a nature that it amounts to a criminal offence, then such cases are not non-arbitrable, and courts will exercise jurisdiction not to refer.
My judgment.
That's right. However, you also said that mere allegation of fraud.
With the Justice Center.
That's right. But you also said that mere allegation of fraud simpliciter
Yes.
is arbitrable. Then later, sir, in Rashid Raza and Evital Studios, the Supreme Court introduced the test of public flavor, the public flavor test. And as to what constitutes a serious allegation of fraud, certain tests were laid down. And what the Supreme Court said there was that if the plea of fraud permeates the entire contract, and above all the arbitration agreement, rendering it void, then those cases will not be arbitrable. However, if the plea of fraud merely touches upon the internal affairs of the parties, then those cases can be referred to arbitration. Later in Vidya Drolia, which is a landmark judgment, it has been held that the allegations of fraud can be referred to arbitration, especially when they relate to civil disputes. And the exception to this rule is that if the fraud has the effect of rendering the arbitration clause itself null and void. And Vidya Drolia has been affirmed it has been affirmed in NN Global.
Yes.
The Law Commission also in its 246 report has proposed addition of a section, subsection 6 in section 16, to provide that arbitral tribunals can rule on aspects of fraud, etc. So with this expanding body of jurisprudence, in my humble view, the courts should follow a balanced approach, a cautious approach, and a principles-based approach, and we can't have a one-size-fits-all.